Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number 2. This morning, you have been asked to come to court for what we call an arraignment. And what the arraignment is an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felony and misdemeanor. Your felony cases are your more serious type offenses, whereas your misdemeanor cases are commonly referred to as your petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about, you can just have a seat. Probably need to be here. Let me get this clip forward. And so when I use the term serious, what I'm talking about the facts of the case, as well as the possible punishment that a person can receive if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, range of punishment minimum 2 years, a maximum of 10 years, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a capital murder, the range of punishment is life in the state penitentiary without the possibility of parole, or death by lethal injection. Now, as I mentioned to you earlier, your case is a misdemeanor case, so you won't have to worry about those type of punishments. Misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, Class B misdemeanor, and the Class C misdemeanor. With the Class C misdemeanor, those cases start in the JP court or the Justice Court or the City Court, which is called the Municipal Court. Now, with a Class C misdemeanor, they come to this court when a person is convicted in the JP court or the City Court, and then they appeal their case. In essence, they want a new trial, and so it comes to this court. The range of punishment stays the same, and the punishment is fine only. The fine cannot exceed $500. And so, if a person, however, fails to pay the fine, or if the fine was converted to community service and they fail to perform the community service, then the court can issue what is called a capias pro fine. That simply means it's a warrant for your arrest to either pay the fine or sit the fine out in jail. And if you sit the fine out in jail, you will be credited $100 per day for every 1 day that you spend in jail. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum $0 to a maximum of $2,000, or you could be placed in jail from 0 days to a maximum of 180 days, which is 6 months in the county jail, or you could be given both such fine and confinement. Now, the highest misdemeanor is a Class A misdemeanor. If a person is convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, or a fine from $0 to $4,000, or you can be given both such fines for fine. Now, you may be eligible for one of 2 types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. What that simply means is that if you successfully complete probation, you will not have a conviction on your record. And you may qualify for what we call a non-disclosure. That just simply means that we cannot disclose the fact to the general public that you are on deferred probation or unadjudicated probation. And it just basically means that your record is sealed to the general public. Now, you notice I use the word general public. That's because the general public cannot have access to your criminal record. However, the government can. For example, law enforcement, just various different governmental agencies that are listed in the Texas Code of Criminal Procedure, they can have access, but most of the public is the general public. So most of the public cannot have access to your criminal record. Now, the other type of probation is called adjudicated probation. Adjudicated probation. Unlike unadjudicated probation, with adjudicated probation, it does result in a conviction on your record. However, there's something that is called judicial clemency. And what judicial clemency is, it gives the court or the judge the discretion to set your conviction aside. And that's you no longer have a conviction. Now, in order to qualify, three things has to happen. One, you have to successfully complete probation. Two, there cannot be any more time left on your probation. And three, you have to be successfully discharged off of probation by the probation department. If those three things happen, then the court has the discretion to set your conviction aside, and you will no longer have a conviction for that case. However, if you get a subsequent conviction, in essence, you get another conviction later on, then what can happen is the case that you received judicial clemency on can be revived, resurrected, or brought back up and used against you. And so if you try to get a license with Child Protective Services, which is CPS, they can deny giving your license, or if you have a license, they can suspend or revoke your license. Now, as a defendant in a criminal case, you have rights. The first right that we will talk about, that I'm going to talk about, is your right to have an attorney. And so I need everyone to make sure that you have the clipboard in your hand, and the first document on the clipboard is titled Judge's Explanation of Rights to Defendants Without Attorney. Okay, everyone should be looking at that document. Now, in that document, it states that as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you cannot afford to hire an attorney, you may request or ask that an attorney be appointed to represent you. And number three, you may represent yourself. Now, if you want an attorney to represent you, you have enough money to hire an attorney. That's what the next paragraph says. You will have to fill out a financial questionnaire. Well, let me back up. If you want an attorney, you have enough money to hire an attorney, your case will be reset. Reset means that you will be given another court date to give you time to hire your attorney. The next paragraph states, if you want an attorney but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire. Now, the financial questionnaire is another document on the clipboard. That document is titled Jefferson County Affidavit of Insurance. And on that document, for those of you who will be requesting a court-appointed attorney, you will have to fill out the first page. And then when you go to the second page, you're going to fill out the top portion where it says defendant's oath, and then the middle portion that says unsworn declaration, and then you'll stop. And then the court will fill out the rest of that document. Okay, now going back to the judge's explanation. Third paragraph says that you cannot talk to the prosecutor about your case unless you first sign a written waiver. That statement is for individuals who will be representing themselves. Now, if you like to represent yourself, you'll be your own attorney, and you'll have an opportunity to talk to one of the two prosecutors about your case. to see whether or not you can work out what is called a settlement or plea bargain, okay, on the case. Now, you cannot talk to them unless you first sign a document that is titled waiver of counsel for purposes of entering the guilty plea or proceeding to trial. It is another document that is on the clipboard, okay? For those individuals who would like to represent themselves, you'll fill out this document, sign it and date it, and then you'll have an opportunity to talk to one of the prosecutors. Now, for those of you who would like to represent yourself, you should be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you, including your case, including the loss of significant rights and opportunities related to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. All right. Now, at the bottom of that document in bold letters, it states, defendant's choice, mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left and date it. Then you go down to the bottom where you put your signature and date today's date, November 19th of 2024. If you've already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney to the right. And then you will sign at the bottom, defendant, and you will date it today's date, 11/19/24. Now, if you would like to apply for a court-appointed attorney, then you will place your initials on the third line to the left. Okay? Then you will sign at the bottom where it says defendant and date it today's date. If you've already been appointed a court-appointed attorney to represent you, then you will place your initials on the fourth line to the left and the name of the attorney to the line to the right. If you would like to represent yourself, then you'll place your initials on the last line, the fifth line to the left, and then you will sign at the bottom and date it today's date. Okay, now just to recap, for all those individuals who will be hiring their own attorney, you will only have to sign one document. The document is judge's explanation of rights of defendants without attorney. Stop. Once you do that, stop. You don't have to sign anything else. All right? Now, for those of you who would like to hire an attorney, well, not hire, those of you who would like to have a court-appointed attorney or an attorney to represent you, and you'd like the court to appoint you a court-appointed attorney, again, you just sign judge's explanation, that's document everybody's gonna sign, judge's explanation, and the affidavit of indigence. Once you fill out, and then you stop. You don't have to go any further. If you would like to represent yourself, that is, you want to waive your right to an attorney, everybody will sign, you'll sign the judge's explanation, and then waiver of counsel for purposes of entering guilty plea, and that's it. Okay? Everyone have it? Okay. Now, as a defendant in a criminal court, in a criminal case, you also have a right to have a trial by jury. But a gentleman is sitting in the jury box, we call that, well, that's the jury box. That's where the jury sits. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence, listen to the arguments of the attorneys. They will go to the jury room, deliberate, and then they will decide whether to find you not guilty or guilty. You can waive or give up your right to have a jury trial. That simply means you will not be having a jury trial. And so your case can come before the court or before the judge in one of 3 ways. It can come before the court by way of a trial. Somebody might say, well, how can it come before the court by way of a trial if I don't have a jury trial? Well, you can have what is called a bench trial. It's a trial by judge only. The judge be the judge and the jury in the case. The judge will listen to the evidence, the judge will listen to the arguments, the judge will apply the law to the facts, and then decide whether to find you not guilty or guilty. Now, you can waive or give up the right to have a trial by judge only, or by bench trial. And if you do so, then you'll be entering a plea. That simply means that you'll be entering a plea of either guilty, which means that you committed the offense that you were charged with, or no contest, which means that you are not contesting the charges. Okay? Now, if you enter a plea in your case, then you can have what is called an agreed plea bargain. What an agreed plea bargain means is that you and the state have talked, or you and your attorney in the state have talked, and they've reached an agreement to settle your case. We call that an agreed plea bargain. Now, if that happens, then the case comes before the judge can do one of two things. The judge can accept the plea bargain agreement or reject the plea bargain agreement. Now, if the judge rejects your plea bargain agreement, that is the agreement that you made with the state, you can simply take your plea back. In essence, you can tell the judge, well, judge, since you're not accepting the plea bargain that I worked out with the state, I take my plea back. In essence, I'm not pleading guilty, or I'm not pleading no contest to these charges. You can do that. Now, if the judge follows the plea bargain agreement, or accepts the plea bargain agreement, and you decide within 30 days that you like to appeal your case, then you have to get permission from the judge to appeal your case. If the judge gives you permission, your case is on leave this court, go right upstairs to the 9th Court of Appeals. They will review your case. They can do one of two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Case over. Or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your appeal, you can appeal it to a higher court than the 9th Court of Appeals. You can appeal it to the Texas Court of Criminal Appeals, which is the highest criminal court in the state of Texas. They're located in Austin, Texas. You will have to file what is called a pro se petition for discretionary review. What that basically means is this. Pro se means that you're representing yourself. And you'll be petitioning the court or asking the Court of Criminal Appeals to review your case to see whether or not your appeal should be granted, or whether or not this court wrongfully convicted you or committed an error by convicting you. They can do one of two things. They can grant your petition or they can deny your petition. If they grant your petition, they can simply find you not guilty. Or they can send the case back to the 9th Court of Appeals with order, or back down to this court with order to give you a new trial. Now, if they deny your petition, then at that point your conviction will stand. All right? Now, as a defendant in a criminal case, you also have a right to have what is called an unagreed plea bargain. What an unagreed plea bargain is this here. You talk to the state, and the attorney talk to the state, y'all can't reach an agreement. You still want to interfere guilty, no contest, but you want the judge to decide what your punishment will be. That's unagreed. And so the judge is simply going to look at the facts of the case and a couple of other things that pertains to punishment. And then the judge will assess punishment within the punishment range. If it's a class A, it's within the class A punishment range. If it's class B, it's within class B punishment range. Now, the other thing is this. You also have a right to have witnesses that come to court. And what a witness do, they'll sit in that chair right there where that microphone is. We call that the witness stand. They can testify for you or against you. And that just simply means you also have a right to waive or give up your right to have witnesses in your case. And what I mean by that is that when we say you're waiving your right to have witnesses, that simply means that you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case that they have against you. Now, you also have what is called a Fifth Amendment right against self-incrimination. I know sometimes you watch television, you see these shows on television about law and order, And you might hear somebody on the television or in the show that says, when the police walks up to them and they want to ask them some questions, they say, well, I take the fifth. That means that I'm not saying nothing. I'm invoking my Fifth Amendment right against self-incrimination, okay? Of the U.S. Constitution, you have a right not to say anything. You have a right not to testify in your own case. The government, the state, the DA's office cannot force you to take that witness stand if you exercise your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination, and if you do so, that simply means you'll take the witness stand. Now, the other right that I like to talk about is your right to have discovery. You know, discovery is like, just by definition, you're seeing something you haven't seen before, right? So the term basically means that in this sense, you have a right to see the evidence that the state has and that the state will be using against you, okay? You have a right to discover or see that evidence. Now, what is that evidence? You have a right to see witness statements, your statements, police reports, lab reports, photos, video recordings, listen to audio recordings. You have a right to have access to any type of documents that they have, rights to have access to any type of instruments that they have. In some cases, it could be a gun, you have a right to have access to that. And so you have a right to have discovery. Now, you also have a right to waive, which means you have a right to give up your right to have discovery. By doing so, you will not have access to the evidence that the state has against you. Now, everyone that's here today, you're here because one, you've been charged with a crime, a misdemeanor case. You've been arrested, placed in the jail, you out of jail on bond. You get out of jail on a cash bond, which means that you paid the full amount of the bond to get out of jail. You're out of jail on a surety bond, which means you paid a percentage of the bond to a bondsman to get out of jail. Or you're out of jail on what we call a PR bond or a personal recognizance bond, which means that you don't have to pay anything to get out of jail. You were released under your own personal recognizance. Now, I say that to say this. Every day that you spent in jail, that jail time can be used as credit toward your punishment. So I say every day that you spend in jail. Now, if you were booked into jail at 11:59 p.m. last night, and you got out of jail at 12:01 this morning, 2 minutes later, that's 2 days in jail. That's 2 different days, okay? So, for example, in a scenario I like to give, say, let's say you spent 5 days in jail. You and the state has worked out a plea bargain agreement. The state has offered that you serve 5 days in jail. That simply means you will not have to serve any more time in jail. Why? Because you've already served 5 days in jail, therefore you'll be given credit for the time that you have already served. Now, if the state is offering 7 days in jail, and you spent 5 days in jail, that simply means that we'll subtract 5 from the 7, and that leaves 2. So you're gonna have to serve 2 days in jail. Now, every day that you spent in jail also can be used as credit toward your fine and court costs. You will be credited $100 per day for every day that you spent in jail. So in our scenario, 5 days in jail, $500. State is offering you as a plea bargain, $500 plus court, fine and court costs of $500. That means you won't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if they're offering fine and court costs of $700, you spent 5 days in jail, we would subtract 500 from the 700, at least 200. And that means that you would have to pay $200. Normally, you'll pay $200 on the day that you enter the plea. If you cannot pay the $200 on the day that you enter the plea, then we can put you on what is called a payment plan, which means you can pay it off in monthly installments. Now, for some individuals, might not have the income, might not have a job, to pay off the money on a payment plan, no problem, because we can convert it to community service. Every 1 hour of community service that you perform in a nonprofit organization, $12.50 will be credited toward your fine and court costs. So for example, if you work 8 hours, that's $100. That will be credited toward your fine and court costs. So in our scenario, you work 2 8-hour days, that's $200, and then your fine and court costs will be paid up by performing community service. Now, Jefferson County has a program that is called pretrial diversion. That is a program for first-time offenders. So if you've never been in trouble before, it's first time getting into trouble, Jefferson County, when I say Jefferson County, I'm talking about the district attorney's office. They have a program that is called pretrial diversion. With pretrial diversion, what they will do, if you qualify and get into the program, they will dismiss your case. And if you complete the program, you can get it expunged off your record. Expunged means erased, deleted, or wiped off of your record. Okay? And in order to qualify for the program, has to be first time getting in trouble. You have to have a lawyer to assist you in doing the paperwork. And the third thing, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. But all other offenses, the DA's office has a program, you can qualify and get into it. And then again, it's wiped off your record. And then it's just like when I was using saying wiped off your record, let's say this is your record. Okay, you see all this here? When it's wiped off, your record looks like that. That case is gone. And so if you're interested in the program, just let us know. We have some brochures that we can direct you to the right person so that you can get into that program. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. It's a program for veterans only. And with that program, what they will do, I'm talking about the district attorney's office, you would have to make an application to get into the veterans program. The only criteria is to be a veteran of any one of the branches of the United States military. That's it. Once you get into the program and complete the program, they will dismiss the case. And then once they dismiss the case, you can get what is called a non-disclosure. That's where your record is sealed. Okay? So if you're interested in those programs, just let us know. We have someone here by the name of Kyle. He'll come to you in a little bit and talk to you more about the veterans program, the Veterans Court program that they have in this county. The other thing about Veterans Court, they have benefits that a person, if you're a veteran, that you can qualify for. And they'll talk more about that in a few minutes. Now, this court has a program that is called the CSI program. CSI stands for Community Safety Initiative. It's a program that started within the first 100 days of taking office back in March of 2017. And with that program, the program is designed to address the issue of what we call recidivism. Recidivism means that when people commit crimes over and over. And so the way we address the issue of recidivism is through the various partnerships that we have with agencies in the community. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop is our local mental health authority. Spindletop has the expertise to address your mental health needs. Now, in order to participate in the program, you do not have to be incompetent or insane. You can just merely suffer from depression or anxiety or any other host of mental illnesses. Spindletop has the expertise to address your mental health needs. Now, with Spindletop will conduct a private interview either in our jury room, at their facility, or by telephone, whichever is convenient for you. They will also do an assessment to determine what your mental health needs are, and they can develop a treatment plan to address your mental health needs. Your treatment plan can either be outpatient or inpatient treatment. Spindletop also has a program that is called ATAR. ATAR ATAR stands for Addiction, Treatment, and Recovery. We also have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR. OSAR is OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery programs. With those programs, they will do a screening, an assessment to determine what your drug or alcohol issues are. And then they can develop a treatment plan, either outpatient or inpatient. You can be referred to either outpatient or inpatient treatment. If you are unemployed, do not have a job, or looking for a better job, we have a partnership with the Golden Triangle Empowerment Center that has a program that has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. Once you're trained in one of those areas, they will help you to get a job in the area that you're trained in. Now, if you haven't graduated from high school and you do not have a GED, then CICE has a GED program where you can get your graduate equivalency diploma. Now, all those programs that I've just mentioned to you are free. Doesn't cost you anything but time. And I like to say in this court, we do not just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say, when you come to county court at law number 2, we don't just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their lives, we'll make a difference in the community. We'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. And we have the brochures that we can give to you so that you can make the contact with the individuals to help you to get into this program. Now, at this time, as I mentioned to you earlier, we have Kyle, who's with the Veteran Administration. He's going to come forward and tell you more about the Veterans Program. And after Kyle comes, then we will have Deputy Hinton. He's going to come and tell you more about the mental health program. Kyle?
Thank you, Your Honor. Good morning, ladies and gentlemen. My name is Kyle Summers, and I'm the United States Marine Corps veteran and Veteran Services Coordinator at Spindle Top Center. Part of my job is to find veterans in our community and connect them to any kind of support in any way, shape, or form. So I work directly with the Veterans Mental Health Department of the Texas Veterans Commission, and I also connect veterans to VA resources as far as the Veterans Treatment Courts, the Jefferson County Veterans Treatment Court as well. And then one of my primary objectives is the Justice Involved Veterans Program. If any of you identify as a veteran, feel free to fill that out on the forms that you were given this morning, and I will reach out to you, see if I can provide you with any support in any way, shape, or form. Thank you.
Thank you, Kyle.
Thank you.
Thank you. My name is Steve Hinton. I'm a mental health deputy licensed by the state commission here with the sheriff's department. The reason Kyle and I are both here this morning is the judge cares about every single person who comes to court bench. So the judge has found, and the statistics prove, is those who have legal issues commonly have mental health needs, substance use disorders, or sometimes just a lack of community resources to help you with your particular situation. Now, maybe this is your first time to be in court, it could be your 5th time to be in court, there's still hope. In fact, what we're offering you today has the ability to change your life, but we need something from you. We need you to convey that need with us. So this is why we handed out this document to you this morning. This is a private way for you to communicate with us, tell us what you need, and we will be in contact with you however you choose to be contacted from this form here. It's about resource and connections. In fact, today, I also want to give you this card here. It has a 1-800 number on there. It's a crisis hotline number. If you ever find yourself in an unsafe place, you can call that number and get help immediately. And I want that to be the first resource we can actually give you today. Now, just shortly, the court is going to go into recess. When it does, we'll be able to come out there and we'll visit with you. I'll pick up these documents from you. We'll answer any questions you may have, and I'll also be giving you one of these cards as well to help you in your journey. Thank you very much. Thank you, Your Honor.
All right, thank you, Deputy Henry. Now, ladies and gentlemen, the paperwork that you have on the clipboard, we're gonna pick that paperwork up. And so, once you fill out the paperwork, we're gonna pick that paperwork up. If you need help with filling the paperwork out, we have our court personnel who is here, and they'll be willing and they're happy to help you fill out the paperwork. Now, this is gonna take a few minutes, a little time, pick up the paperwork. If you need to use the restroom, there are two restrooms right outside in the hallway. The men's restroom is in front of County Court at law number 3. And the female restroom is on the opposite side of the hall, in front of the 172nd District Court. Now, you're allowed to use the restroom and come back in. Now, please do not leave the courthouse. You leave the courthouse, your name is called, you're not here, your bond can be forfeited, and if your bond is forfeited, a warrant will be issued for your arrest. Okay, so again, if you need some help with the paperwork, just let us know. We have our court personnel here, and if somebody speaks Spanish, we have an interpreter that is also here who will be able to help you fill out the paperwork. Okay? So at this time, we're going to go into recess. I think Spindletop and Deputy and Kyle may come out to you and talk to you a little bit. But we're gonna pick that paperwork up. I'm gonna call you up to the bench, I'm gonna pick the paperwork, and so you can go ahead and get your case reset or whatever to get out of here. All right? So it's gonna take us a few minutes. So at this time, the court will be in recess.
Before you go outside, please finish your paperwork, because if not, you're the last one. You can raise your hand and bring it off, move on.
to the best of your knowledge. Okay? Ms. Thomas, I read your answers. The case is gonna be reset. And it's gonna be reset for what we call an announcement. Once you get your case reset, you're free to go. And you have a blessed day. You have a blessed day.
Thank you, Rob.
Thank you. Yep, Jefferson County Court, Number 2 is back in session. Court is in session. And call number 24 CCCR 2118. Case is style of the state of Texas versus Nicole J. Ardwine. Ms. Ardwine, is that your full name?
Yes.
Ms. Ardwine, would you please raise your right hand? So Ardwine, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Ardwine, you may put your hand down. How are you doing, Ms. Ardwine?
I'm fine, how are you?
I'm doing fine, thanks for asking. And I think Ms. Ardwine, you appeared in court last week. And you signed a judge's explanation of rights to defendants without an attorney. And you stated you wanted to waive your right to an attorney, represent yourself.
Yes, sir.
And you also signed a waiver. A waiver of counsel for purposes of entering a guilty plea or proceeding to trial, is that correct?
Yes, sir.
And before you signed those documents, did you read those documents?
Yes, sir.
You understand what you read?
Yes, sir.
And is everything in those documents true and correct
Yes,
to the
sir.
best of your knowledge?
Yes, sir.
Okay, Ms. Ardwine, I have before me a motion to dismiss your case. State, is that correct?
Yes, Your Honor.
Okay, state is dismissing your case. I'm signing the dismissal. You'll be able to get a copy of the dismissal in a few minutes. Once you get a copy of this dismissal, you're free to go. You can talk to an attorney about perhaps getting this expunged from your record. Ms. Jackson, maybe get this document to her. You can stand in front of the court coordinator. She's gonna give you your dismissal. Once you get your dismissal, you're free to go and you have a blessed day.
Yes, thank you.
You're welcome.
We can write off that board. Is it working on it?
Not even a door. Oh, Jefferson County Court, Law number 2 is back in session. The court is in session with the arraignment docket. And the first case that we have on the arraignment docket is cause number 24 CCCR 2136. Case is style State of Texas versus Andre Pierre Holloman. Holloman, would you please come forward? Mr. Holloman, your full name is Andre Pierre Holloman. Mr. Holloman, would you please raise your right hand? Mr. Holloman, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Holloman, you may put your hand down. How are you doing, Mr. Holloman? You doing good? That's good. Now, Mr. Holloman, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Now, before you signed and initialed this document, did you read the document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Holloman, your case is going to be reset. Please stand in. You need to have him seated. Please stand in front of the court coordinator. She's going to give you a reset. Once you get your reset, you're free to go and you have a blessed day. Rudolph Anthony LaSaint. Mr. LaSaint, your full name is Rudolph Anthony LaSaint.
Yes, sir.
Mr. LaSaint, would you please raise your right hand? Mr. Slank, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. LaSaint, you may put your hand down. How are you doing, Mr. LaSaint?
I'm fine, yourself.
That's good. Now, Mr. LaSaint, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes.
There's a set of initials on the line that is titled, well, that states you'd like to have your case reset to hire your own attorney.
Sure.
Now, before you signed and initialed this document, did you read the document? Do you understand what you read? Is everything in this document true and correct to the best of your knowledge?
Yes.
Okay, Mr. Saint, your case is going to be reset to give you an opportunity to hire your own attorney. Stand in front of the court coordinator so she can give you reset. Once you get your reset, you're free to go and you have a blessed day. Next case is Diego Godinez. Okay, just have a seat. Okay, somebody call an interpreter. Next case is let's see, it's, what is this? You say Mr. Henry has another case?
Yes.
Is it on the docket? Okay, I need to see that. I need the cause number.
I'm sorry, I left it right here.
Okay, Mr. Henry, Christopher Henry, please come forward. Court is in session in 3 cases. Cause number 24 CCCR 1774, cause number 24 CCCR 1775, and cause number 24 CCCR 2682. All 3 cases are styled in the state of Texas versus Christopher Taylor Henry. Mr. Henry, is that your full name? Mr. Henry, would you please raise your right hand? Mr. Henry, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Henry, you may put your hand down. How are you doing, Mr. Henry?
Alright.
I'm doing fine, thanks for asking. Now, Mr. Henry, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
Sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled, hold on a minute. What's the offense on the third doc, on the new case? Okay, hold on a minute, I need to. Let me see about conditions, okay. I do that at the end. Let's let me look at it. Hold on a minute.
You got a question about the PR bond, you can ask, hold on a second.
Okay, Mr. Henry, I have before me, two documents. First document states that, well, it's titled Judge's Explanation of Rights to Defense by Attorney. Now, do you recognize this document?
Sure.
And is this your signature on the line that said defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that's titled Jefferson County Affidavit of Indigence. Recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled defendant signature. Is this your signature?
Yes, sir.
Now, Mr. Henry, before you sign and initial these documents, did you read your documents?
Yes, sir.
You understand what you read?
Yes, sir.
Is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Okay, Mr. Henry, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. An attorney that will be appointed to represent you in this case is Attorney Laura Peraza. Attorney Peraza will be given permission to contact you. You will also be given permission to contact her. Our court coordinator is going to give that information to you before you leave here today. Now, before the court coordinator give you that information, I need to give you some bond conditions. Ms. Bailey, could you just hand this document to Mr. Henry? Mr. Henry, the bailiff is handing you a document that is titled Standard Bond Conditions in County Court at Law number 2. Do you see that title?
Yes, sir.
Okay, I'm going to go over these bond conditions with you. So, a minute. And this document is titled Standard Bond Conditions in County Court at Law number 2. Following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. Court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submits to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition? And condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of a pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Okay, now condition number 4 does not apply. That only applies in the DWI case. Condition number 5 does apply. Condition number 5 states the defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Henry, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant shall be issued for your arrest. Now, you have a warrant out on this case, you'll be transported to the Jefferson County Jail, and the magistrate at the jail will set your bond. Okay?
Okay, well, did I ask you about a PR bond?
The magistrate at the jail will set your bond. Okay, you could ask the magistrate at the jail. All right. Yeah, that's your copy. Did you give him his reset? He has to get his reset.
I'll get it.
Okay, she'll get your reset.
One.
We need to get an interpreter.
Yeah, or.
We're doing this. Haley Schomeyer. This is cause number 24 CCCR 2340. Case to style the state of Texas versus Haley. Is that Schulmeyer? Schulmeyer? Ms. Schulmeyer, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Ms. Schulmeyer? I'm doing fine, thanks for asking. Ms. Schulmeyer, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I have another document that is titled Jefferson County Affidavit of Innocence. Do you recognize this document? On page 2 of the same document, there's a signature above the line that is titled defendant. Is this your signature? Now, Ms. Schulmeyer, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Schulmeyer, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will give information to contact you. You will be given information to contact her. Our court coordinator will give you that information. But before she gives that information, I need to give you some bond conditions. Mr. Hubel or Miss Jasper, you have a minute? Either one, don't make a difference. Now, Ms. Schumer, I have some bond conditions. We may have to modify them. Now, Ms. Schumer. I have to give you a document that is titled Standard Bond Conditions in County Court at Law Number 2. And, could you just show her this? Oh, you have one?
Oh, I was showing her the copy that you gave me, Your Honor.
You can look at that one and she can get the one that's signed. Okay, now Ms. Schumer, the document that you have in your hand is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes, sir.
Okay, and it states as follows: following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall not commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
Okay, now, on condition number 3, before I read that to you, now, the victims in this case, is your parents, is that correct? Do you live with your parents or do you live with someone else?
I live with my parents.
Okay. Okay, so I can change this to, she can't communicate with her parents in a threatening or harassing manner.
Yeah.
Okay. Alleged victim, and it shall not, let me see, shall not communicate either directly or indirectly with the alleged victim of the pending offense.
You had a question, Judge.
Yeah, hold on a minute. In a threatening. Okay, what was the question?
My dad lives in Florida and he's willing to take me if my mom is willing to give over custody.
Oh, well, that's between your parents. Yeah, I don't have, I guess the word would be jurisdiction. I don't have no control over that. Okay. Okay. So this condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense in a threatening or harassing manner. Do you understand that?
Yes, sir.
Okay. Now, number 4 does not apply. Okay, because that applies in the DWI case. Now, number 5 does apply. And number 5 states the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 107 of the Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that?
Yes, sir.
Okay. Now, you're not working, is that correct? You're not working? And are you in school?
Yes, sir.
Hold on a minute, let me do this here. if your bond is revoked, that means that, you can be, a warrant can be issued for your arrest and you can be put in jail. You understand that?
Yes.
All right, this is November. Okay, let me ask you this. How are your grades in school?
Most of them are okay. I'm just struggling in two subjects.
You said most of them okay, you're struggling in 2 subjects?
Yes.
Okay, now the subjects that you're struggling in, have you always struggled in those subjects?
Yes.
So it's,
Sergeant, that's her mom.
okay, ma'am, you can come up if you,
She would like to tell you what happened last night.
well, I can't get into that. I'm not gonna, we can't get into what happened last night. Now, if you just wanna be here for support or something like that, that's fine. But as far as anything about the case, or we can't get into that, okay? Okay, because it's just, inappropriate, for us to, go into anything about the case, and we're not here for that. Okay, now this is her arraignment. She has an attorney that has been appointed to represent her. Did I tell her who her attorney was? Yeah, I already told you, yeah. Your attorney and Ms. Marva Provo is your attorney. Okay, she's going to, contact you. Because we're going to give her information to contact you. And we will also give you information to contact her. So anything that y'all need to, talk about, you can talk to her about that, and just a reminder. Earlier, I mentioned that you have a Fifth Amendment right against self-incrimination, which means that you have a right not to say anything, against yourself, okay? And you have an attorney. Your attorney could be present with you before and during any question. Okay, so at this time, we're not going to ask you, any questioning. We're not going to ask you any questions about the case. You're not under custody, so you will not be any type of custodial interrogation.
Yes.
All right. So, but my question to you, regarding you say you're struggling in 2 courses. Have they received their first full card yet?
Yes.
They have? Okay. Now,
Usually every 6 weeks.
after 6 weeks, now, let me tell you this here. I would imagine they have tutoring at school. Okay. Do you go to the tutor? You need to go to the tutor.
Yes.
Okay. And, now we want to make sure that you will, give 100% in class.
Yes.
Okay. Now, you need to, I don't know how your attendance is, but you need to, attend school, and you need to participate in the programs at school. You need to participate in the tutoring program.
Yes.
Because I had to, tutoring is good for you. I had tutoring, okay? Because a lot of times they can simplify, things. It's a lot of one-on-one. And so a lot of times the teacher may not have enough time to, devote to you, but the tutor does.
Yes.
Okay, so what I'm going to do, I'm gonna put another condition in here that you must, attend school, because obviously you know that if you have so many absences, they could, file truancy charges on you and that type of stuff, okay? Which is a violation of the law, which it will be a violation of your bond condition, right? if it's an offense against the state of Texas, that's a violation of your the first bond condition. Okay? Um. uh, Let me do this here. Andrew. This is, Ms. Schulmeyer, and I need to, okay, I can just do like this. Yes, could you make we're gonna have to make a copy of it. You can tear that, you can tear that one up. Let me give you a copy of this one. So we made some changes. You can tear it up and you can give it to the bailiff. We're gonna make copies of this. Okay. Christopher Pickens. Schulmeyer, here you go. She's gonna make a copy of this here. Okay. Mr. Pickens, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Pickens, you may put your hand down. How are you doing, Mr. Pickens? I'm doing fine. Thanks for asking, Mr. Pickens. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
On page 2 of the same document, there's on a different document, this document is titled Jefferson County Affidavit. You recognize this document?
Yes, sir.
And is this your signature on this document?
Yes, sir.
Now, Mr. Pickens, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Mr. Pickens, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you. You will also be given information to contact him. But before I give you that information, I need to give you some bond conditions. Would you please step to the right and let me hand these bond conditions to you? You can step back. Now, Mr. Pickens, this document that you just been handed is titled Standard Bond Conditions in County Court Law Number 2. Do you see that document?
Yes, sir.
That title. Now, this document states, following the return of a criminal information in County Court Law Number 2 of Jefferson County, Texas, all bail bonds to execute release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant is prohibited. Well, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense. The defendant shall not go to any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And condition number 4 does not apply. However, condition number 5 does apply. Condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition? Now, Mr. Pickens, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant shall be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Mr. Pickens, please have a seat. You're gonna have a seat in that first chair and wait for your name to be called. Once your name is called, you're gonna go to the window, window of the court coordinator and follow her directions. You'll be free to go and you have a blessed day.
Thank you.
You're welcome. Yeah, just have a seat in that chair at the table. That'll be fine. Both of y'all can sit at the table. Oh, no, she has them. Okay, she has your bond condition. Okay, Ms. Schulmeyer, remember what I said.
Remember what I said too?
Okay, all right.
I'm coming.
I'm scared.
Stay scared.
Okay,
I'm coming.
okay. All right, y'all have a blessed day.
Bye.
Caden Wayne Broussard. You have his paperwork?
Daddy, you wanna go there with me, Dad?
You have his paper. I guess I already did the judgment. Okay. This is, clause number 24 CCC Aura 2196. Case is style of state of Texas versus Caden Wayne Broussard. Mr. Broussard, is that your full name?
Yes, sir.
Mr. Broussard, would you please raise your right hand? Mr. Broussard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Broussard, you may put your hand down. How are you doing, Mr. Broussard?
Good, how about you?
I'm doing fine, thanks so for asking. Now, Mr. Broussard, before we get started, I need to inform you that you have a right to have a record made of this case. That is, you have a right to have a court reporter to type down everything that's being said. However, you also have a right to waive or give up your right to have a record in this case. Do you waive or give up your right to have a record? Okay, now, Mr. Broussard, I see that you're not here long and you have someone who's here with you. And who do you have?
Yeah.
Okay, what's your dad's name?
Carl.
Carl Broussard?
Yes, sir.
How are you doing, Mr. Broussard?
And here you.
I'm doing fine. Thanks for coming down here with your son. Now, Mr. Caden Broussard, I have before me two documents. The first document is titled Judge's Explanation for Rights to Defendants Without Attorney. You recognize this document?
Sir.
And is this your signature on the line as titled defendant?
Yes, sir.
Or these your initials on the line that state you want to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea of Proceeding to Trial. You recognize this document?
Yes, sir.
And is this your signature on the line as titled
Yes,
defense?
sir.
Mr. Broussard, Mr. Caden Broussard, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge? Okay. Now, Mr. Caden Broussard, I also have a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Broussard, it alleges that you, Caden Wayne Broussard, on or about July 26th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest detention. Mr. Broussard, do you understand what you have been charged with?
Yes, sir.
And to this charge, Mr. Broussard, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
That's what no contest means. You don't want to fight or contest the charges.
Yes, sir.
Okay, now, Mr. Broussard, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are two sets of initials. First set of initials is the lower paragraph that's titled waiver, and the initials are on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
The second set of initials is below a paragraph that is titled discovery admonishment, and it is on a line next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
on page 3 of the same document, there is a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
On the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Broussard, are you a citizen of the United States?
Yes, sir.
Okay.
Zero for stage one.
Now, Mr. Broussard, the state is offering state's exhibit number 1 to be used as evidence against you in your case. State's exhibit number 1 is the first document that I showed you on this tab. This is the same document that have your initials and the 2 locations on page 2 and your signature at the top of page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objections. State's exhibit number 1 will be admitted. Now, Mr. Broussard, is there any evidence that you are currently mentally incompetent to stand trial? Is there any evidence that you have a mental illness and you do not understand what's going on within your case and why you're here and the rights that you have? You understand all this?
Yes, sir.
Okay. So the court is going to accept your plea of no contest. The court will find that you are mentally competent to stand trial. The court will also find that your plea and waivers were freely and voluntarily given. The court will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
The agreement in this case, on the evading case, is 6 months deferred probation with a $200 fine plus court costs and 24 hours community service. The connected failed ID case will be dismissed, and the defendant in this case will be given credit for 5 days jail towards fine and court costs.
Okay, so you're gonna dismiss the,
Failed
okay,
ID.
okay. Dismiss 24CCCR 2197. Is it pass? Yeah. Okay. Guys, what's the court cost? 277. Okay, that's gonna be 1. And what, let me see this, 620. Just got to chase on that. And he got $500. He got 5 days credit, right?
That's correct, Your Honor.
Okay. Okay, Mr. Broussard, the state is offering that you serve 6 months deferred adjudicated probation. During the 6 months probationary period, you'll be required to pay a fine of $200. Those court costs are $277. You'll be required to pay a probation fee of $60 a month, urinalysis fee of $15 a month, reimbursement fee of $15. Now, your total monthly installments is $188 a month. Now, the state is giving you 5 days credit for the 5 days that you spent in jail. So therefore, you would not be required to pay because it has paid off your fine and court costs. So instead of paying $188 a month, you'll be required to pay $93 a month. Do you understand that?
That's gonna be for the probation.
Yes. There's $93 a month. Now, will you be able to pay the $93 a month?
He don't have a job. He's
Okay.
still in school.
Okay,
He's
well,
17 years old.
okay. Well, let me do this. Is there an affidavit of indigence in the file? I just need to see if there's an affidavit of indigence. Better be. Okay. 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 I have before me a document that is titled Affidavit of Indigence. I'm going, Mr. Broussard. Yes. Mr. Huber, could you hand this to Mr. Broussard? Mr. Broussard. Attorney Huber is handing you a document that is titled Affidavit of Indigence. Do you recognize this document? It's the document that was filled out while you were in custody?
Sir,
Huh?
yes, sir.
Now, is everything on that document still true and correct regarding your income?
Yes, sir.
Okay. Now, Mr. Broussard, I'm going to find that you're indigent. And basically what that means is that you're not able to afford fines and court costs in this case. So the court is going to find that you're indigent pursuant to Article 42.15 of Texas Code of Criminal Procedure. And based on that finding of indigency, the probation fee will be reduced to the statutory minimum of $25 a month. Okay, instead of $60 a month. And your total monthly installments, you'll be required to pay. Well, the court will waive the reimbursement fee of $15. That means you won't have to pay it. And it's pursuant to Article 102.018 of Texas Code of Criminal Procedure. You will be required to pay $25 a month for the probation fee and $15 a month for the your analysis. So your total monthly installments for this case will be $48 a month. Will you be able to pay the $48 a month?
Yes, sir.
Okay. Now, the state will also be dismissing the companion case cause number 24 CCCR 2197. All right. And we're going to have that paperwork for you in a minute. She has to make the adjustments. based on your paperwork, based on what I just told you, because you're indigent. Now, do you understand the state's offer?
Yes, sir.
You think it's fair and just?
Yes, sir.
You, and as well as you think the adjustments that the court made is fair and just?
Yes, sir.
And do you accept it?
Yes, sir.
Okay, I'll follow plea bargaining agreement with the adjustment the court has made. Please have a seat in that first chair, wait for your name to be called. Once your name is called, you're gonna follow the directions of the bailiff. Once you follow the directions of the bailiff, you'll be free to go and you have a blessed day. All right, and thanks for coming out here. Let me do this here, but thanks for coming out here with your son, Mr. Broussard. Now, Caden, I know a lot of times, you know, people, you know, young folks always say, you know, they have friends. You call them your BFF, your best friend for life. And these friends will be with you through thick and thin. But on days like today, when you need a friend, I don't see those people that you call your BFF. They're not here. You know why they're not here? Because they're not your BFF. Your BFF is standing next to you. That's the man that put a roof over your head, clothes on your back. I see you got some jewelry around your neck, right? He puts food on the table. That's your BFF. And he's doing that because he loves you. Okay? You're blessed. Everybody doesn't have a father like he is. Okay?
Yes, sir.
And he's there with you through thick and thin. I know you might feel as though you're at rock bottom, right? But you're not at rock bottom, and you might feel that you're in a storm. But you're not, yeah, well, you might be in a storm, but guess what? When you're walking through a storm, hold your head high. Don't be afraid of the dark. At the end of the storm, there's a golden sky and the sweet silver songs of the Lord. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown, walk on with hope in your heart, and you never walk alone. And you know why they say walk on with hope? Because when you're drowning in things, hope floats. You can hold on to that hope, okay? And hold on to that man that's next to you because he's here with you, right?
Yes, sir.
He's here with you and he's gonna be here with you, okay? And Mr. Carl Broussard, thanks for coming out here with your son. I know he was like most kids, like myself, when I was like you yourself, we didn't do everything our parents said. But you know, they hung in there with us.
Yeah, they did.
All right, just hang in there with him. He's gonna be all right. Okay. This is not a stumbling block. This is a stepping stone. And you know the difference between a stepping stone. You can step on a stone and reach some higher things. You got some goals in life that you want to reach, you can reach it. This not gonna interfere with it. And guess what? If you successfully complete this probation, the case gonna be dismissed, and you won't have this on your record. You can get a non-disclosure. You could talk to a lawyer about that. All right?
Yes, sir.
All right. Y'all have a blessed day.
Reimbursement fee.
Yeah, minimum, yeah, it reduced to $25.
And don't forget to send us dismissal.
Yeah, I'm doing that now. Jose Landeras Chavez. This is cause number 24 CCCR 2180. Case is style of state of Texas versus Jose Landeras Chavez. Mr. Landeras Chavez, is that your full name?
Yes, sir.
Mr. Landeras Chavez, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
You may put your hand down. How are you doing, Mr. Landeras Chavez?
All right.
I'm doing fine. Thanks for asking, Mr. Landeras Chavez. Before we get started, you have a right to have a record made, which means you have a right to have the court reporter sit here and type everything we say. You also have a right to waive or give up a right to have a record made. You waive or give up your right to have a record? Okay, now, Mr. Landaris Chavez, I also have before me two documents. First document is titled Judge's Explanation of Rights for Defense Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled Defendant?
yes, sir.
Are these your initials on the line that state you would like to waive your right to attorney and represent yourself?
Yeah.
I also have another document that's titled Waiver of Counsel for Purposes of Inter Guilty Plea or Proceeding in the Trial. You recognize this document?
Yeah.
And is this your signature on the line that's titled Defendant? Before you sign and initial these documents, did you read the documents?
Mhm.
Did you understand what you read?
Yes,
And is everything in these documents true and correct to the best of your knowledge?
yes, sir.
Now, Mr. Landaris Chavez, I also have before me a document that is titled Information. This document is on my computer. And this information, it alleges that you, Jose Landaris Chavez, on or about August 11th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offensive theft. Mr. Landaris Chavez, do you understand what you've been charged with?
Yes.
And to this charge, Mr. Landaris Chavez, how do you plead? Guilty, not guilty, and no contest?
Guilty.
Now, you're pleading guilty freely and voluntarily? And are you pleading guilty because you are guilty?
Yep.
Mr. Landaris Chavez, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishments. You recognize this document?
Yes.
On page 2 of the same document, there are two sets of initials. First set of initials is below a paragraph that is titled a waiver. It is on a line next to a box that says check guilty. Did you place your initials JC on this document?
Yes.
On the next line, the signature, a set of initials is on a line below a paragraph that is titled Discovery Admonishment, and is on a line that states, I do not request discovery of the evidence. I waive my right to request discovery in this case and enter a plea of guilty or no contest. Did you place your initials on this document?
Yeah.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes.
And on the next document that's titled Trial Court Certification, Defendant's Right of Appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case. You have no right of appeal. You understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement?
Yes.
Now, before you sign and initial these documents, did you read the documents?
Yes.
And you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? And Mr. Landaris Chavez, are you a citizen of the United States?
Yes.
State offers states one.
Now, Mr. Chavez, Landaris Chavez, the state is offering State's Exhibit Number 1 to be used as evidence in this case. State's Exhibit Number 1 is the first document that I showed you on this tablet. This is the same document that has your initials in these two locations and your signature in this location. Is it all right for the state to use this document as evidence in your case?
Yeah.
Okay, no objection. State's Exhibit Number 1 will be admitted. Mr. Landaris Chavez, is there any evidence that you are currently mentally incompetent to stand trial? There's none? Okay, Mr. Landaris Chavez, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
In exchange for defendant's plea, the state is offering 90 days in the Jefferson County Jail, probated over 1 year, $300 fine, 40 hours of community service, a theft class, and court costs.
Okay. Let's see. What is this court cost?
$277.
Okay. Mr. Chavez, Darren Chavez, the state is offering that you serve 90 days in Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs, $277, probation fee of $60 a month, your analysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month while you are on probation, is $136 a month. Will you be able to pay the $136 each month?
Is there any way we can like lower?
Do we, I need to see if he has an affidavit. We need to see if you have an affidavit right quick. Just hold on a minute. Oh, he's gonna have to, you have to get him one and he's gonna fill out the first page. Mr. Landera Chavez, the bailiff is gonna hand you a document that tells an affidavit of indigence. You need to, fill out that first page. You looking for one on that? She has one right there.
It's right there.
Just have a seat at that table and, you're gonna fill out information out. There's not actually for your financial information and your expenses. And once you're finished, we'll call you back up. Next case. Darius Moore Lockett. Mr. Lockett, you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Lockett, you may put your hand down. How are you doing, Mr. Lockett?
Well, then you, sir.
I'm doing fine, thanks for asking. Mr. Lockett, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes,
And is this your signature on the line that's titled Defendant?
yes, it is.
Or these your initials on the line state you'd like to waive your right to attorney and represent yourself?
Yes, it is.
I also have another document that's titled Waiver Counsel for Purpose of Inter Guilty Plea Proceeding Trial. You recognize this document?
Yes,
And is this your signature on the line that's titled
yes,
Defendant?
it is.
Now, before you sign and initial these documents, did you read the documents?
Yes,
Did you understand what you read?
yes,
And is everything in these documents true and correct
yes.
to the best of your knowledge? Okay, Mr. Lockett. I also have before me on my computer a document that is titled Information. This information is filed by the Jefferson County District Attorney's Office. But before I get into that, I need to tell you, Mr. Lockett, that you have a right to have a court reporter to type down everything that's being said. You can waive or give up your right. Do you waive or give up your right?
Yes, I do.
Okay, you waive. Now, Mr. Lockett, on my computer, I have a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Darius Moore Lockett, on or about August 21st of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of theft. That now this offense is a Class A misdemeanor because this information further states that prior to the presentment of this, before the commission of this offense, that you were convicted of theft on August 24th of 2021 in the County Court at Law number 2 of Jefferson County, Texas, and cause number 328222. Is that true?
Yes, it is.
And to the offense of theft, enhanced, how do you plead? Guilty, not guilty, or no contest? Guilty. Now, you pleading guilty freely and voluntarily?
Yes,
And are you pleading guilty because you are guilty?
yes,
Mr. Lockett, I also have before me a document that's titled Misdemeanor Plea Admonishments. Recognize this document?
yes, I do.
On page 2 of the same document, there are signatures on a line next to a box that's checked guilty. Well, some initials. Did you place your initials on this line that's titled guilty?
Yes, I did.
And there's another set of initials on a line next to a statement that reads, I do not request the discovery of the evidence. I waive my right to discovery of the evidence in this case and choose to enter a plea of guilty, no contest. You place your initials on this document.
Yes.
On page 3 of the same document, there's a signature on a line next to a box, a bit above a line that is titled defendant. Is this your signature?
Yes, it is.
On the next document that's titled trial court certification of defendant's right of appeal, you recognize this document.
Yes, I do.
And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box is checked, states that this is a plea bar in case you have no right of appeal. You understand the statement. Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Now, Mr. Lockett, before you signed and initialed all of these documents that I showed you, did you read the documents?
Yes, I did.
Did you understand what you read?
Yes, sir, I did.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Lockett, are you a citizen of the United States?
Yes, I am.
Stay for stage one.
Now, Mr. Lockett, the state is offering State's Exhibit number 1 to be used as evidence in this case. State's Exhibit number 1 is the first document that I showed you on this tablet. This is a document that has the first box that's checked, and it's a class A misdemeanor. It's also the same document that have your initials in the 2 locations and your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
No objection. State's Exhibit number 1 will be admitted. Mr. Lockett, is there any evidence that you're currently mentally incompetent to stand trial? Mr. Lockett, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers was freely and voluntarily given. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is the agreement?
The agreement in this case is to 180 days probated over 15 months with a $500 fine and 50 hours community service.
What is this court cost? Okay, Mr. Lockett, the state is offering that you serve 180 days in Jefferson County Jail. You do not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 15 months. During the 15-month period, probationary period, you'll be required to pay a fine of $500 plus court costs of $277, probation fee of $6 a month, your analysis fee of $15 a month, reimbursement fee of $15. The total amount in installments, that is the total amount that you will be required to pay each month, is $137 a month. Will you be able to pay the $137 a month? Okay, we need an affidavit of injuries on him. Okay, we're gonna have to get him to fill one out. That's all you did? Yeah, yeah. He can maybe sit at that table and fill it out. Okay. Jorge Ortiz. All right. Who's here? This is cause number 24 CCCR 2106. Case is styled the state of Texas versus Jorge Ortiz. Mr. Ortiz, is that your full name?
Jorge Luis Ortiz.
Jorge
Luis
Ortiz?
Yes, sir.
Mr. Ortiz, would you please raise your right hand? Mr. Ortiz, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Ortiz, you may put your hand down. How are you doing, Mr. Ortiz?
Tired.
You tired? Okay. Now, Mr. Ortiz, I have before me, where's his paperwork?
It's right here.
Okay, I have before me a document, two documents. The first document is titled Judge's Explanation of Rights of Defendants without Attorney. You recognize this document? And is this your signature on the line entitled Defendant?
Yes, sir.
Are these your initials?
I don't,
He put a check mark right there.
yeah, I put my check mark.
Yeah, you have to put your initials right there.
Thank you.
Okay, now, are these your initials on a line that states you'd like to waive your right to an attorney and represent yourself? Yes, sir. I also have another document. This document is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Ortiz, before you sign and issue these documents, did you read the documents?
Yes, sir.
Understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Ortiz, I also have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jorge L. Ortiz, on or about July 5th of 2024, while you were in Jefferson County, Texas, that while you was in Jefferson County, Texas, that you was reckless driving with a motor vehicle on a public road or place in Jefferson County, Texas. Do you understand what you've been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, or no
Guilty, sir.
contest? Guilty?
Yes, sir.
Now, you're pleading guilty freely and voluntarily?
Freely
And are you
yes.
pleading guilty because you are guilty? Now, Mr. Ortiz, before we go any further, you have a right to have a record made of this proceeding, which means you have a right to have somebody type down everything that's being said. You also have a right to waive or give up that right to have a record. Do you waive or give up your right to have a record? Okay, you waive or give it up. Now, in State's Exhibit number 1, there are a set of initials in 2 locations. The first set of initials are on a line next to a box that's checked guilty. You place your initials on that document.
Yes, sir.
The second set of initials is on a line that's next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in the case pending against me and choose to enter a plea of guilty or no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document?
Yes, sir.
And is this your signature?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal. Do you understand that?
Yes, sir.
Okay, now, before you signed and initialed these documents, did your attorney, did you go over these documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct
Yes, sir.
to the best of your knowledge?
Yes, sir.
And Mr. Ortiz, are you a citizen of the United States? State, you have any evidence?
Yeah, stage 1.
Now, State is offering State's Exhibit number 1 to be used as evidence in this case. State's Exhibit number 1 is the same document that the first document that you saw and recognized on this tablet. It is the same document that where you acknowledge that these were your initials in these 2 locations and your signature on page 3. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
Okay, no objection. State's Exhibit number 1 will be admitted. Now, Mr. Ortiz, is there any evidence that you're currently mentally incompetent to stand trial? Okay, now, Mr. Ortiz, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement is to a $200 fine plus court costs.
Okay, what is the court cost?
3:30.
330. Now, Mr. Ortiz, the state is offering that you pay a fine of $200 plus court costs of $330. Are you able to pay the fine and court costs, which comes to a total of $530? Okay. Mr. Ortiz, do you understand the state's offer?
Yes, sir, but can I do it in like two payments, cause I can't do it in one payment?
We would have to put that in the paperwork.
Uh-huh.
I mean, not only,
Well, I could pay it Wednesday, but, I mean,
we can have you to pay it Wednesday.
yeah, I could pay it on Wednesday.
Okay. That's tomorrow, it's the 20th.
But, yeah, my check comes in tomorrow night, so I'll be able to pay tomorrow night.
Yeah,
You say tomorrow night, so it'd be Thursday then?
Thursday he'll pay it, so he'll
No,
pay
I
it
can pay
on
it,
the
I
21st.
work night shift, I work nights, so when my check comes in, I'll be able to pay it online, or my girlfriend can pay.
I don't think you can pay it online.
Yeah,
can you?
it'd have to be in person.
Okay, well, I'll come and pay it in the morning when I get off, at 6 in the morning whenever y'all open.
So is it?
Tomorrow morning?
Yeah, well, cause I get off at 5 tomorrow. I work nights.
You get off at 5 in the morning, he said.
Okay.
He gonna pay it tomorrow.
Tomorrow, 20, okay?
Okay.
She just said
Oh, no,
Thursday.
yeah, Thursday morning. 'Cause-
Oh, okay.
Oh, I'm sorry, y'all.
Okay, so
Oh,
you're
you
gonna
want
pay
days?
$500 payable on Thursday, which is November 21st of 2024. Okay. All right. Now, you understand the state's offer?
Yes, sir.
You think the state's offering your case is fair and just? All right. I'll follow plea bargain agreement that you enter to a state, once you have a seat. And, we're gonna call Mr. Ladaris. Yes.
I think it's mom.
See Lumpkin.
Okay, this is cause number 24 CCCR 2168. Case is style the state of Texas versus Stacy Lumpkin. Ms. Lumpkin, is that your full name? Ms. Lumpkin, would you please raise your right hand? Ms. Lumpkin, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Lumpkin, you may put your hand down. How are you doing, Ms. Lumpkin? That's good. Now, Ms. Lumpkin, I have before me two documents that is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line that state you like to waive your right to attorney? What? Yeah, you like to waive your right to an attorney and represent yourself?
Yes.
I also have another document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea or Proceeding to Trial. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? Ms. Lumpkin, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read? And is everything in these documents true and correct
Yes.
to the best of your knowledge? Ms. Lumpkin, I read your answers. Now, Ms. Lumpkin, we're going to proceed. You have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter, which means you have a right not to have a court reporter. You waive or give up your right to have a court reporter? Okay, Ms. Lumpkin, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Ms. Lumpkin, it alleges that you, Stacy Lumpkin, on or about August 3rd of 2023, while you were in Jefferson County, Texas.
2024,
Excuse
Your
me.
Honor.
Okay, August 23rd of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft. Ms. Lumpkin, do you understand what you have been charged with?
Yes.
And to this charge, Ms. Lumpkin, how do you plead guilty? Not guilty or no contest?
No.
Now, you pleaded no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Ms. Lumpkin, and I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishment. You recognize this document?
Yes.
On page 2 of the same document, there's 2 sets of initials. First set of initials is below a paragraph that's titled waiver, and it is on the line next to a box that's checked guilty. Did you place your initials SL on this document?
Yes.
The second set of initials is below a paragraph that is titled Discovery Admonishment, and it is on a line next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to waive my right to discovery of the evidence in this case and choose to enter a plea of guilty or no contest. Do you understand that statement? I also have a signature on page 3 above the line that's titled defendant. Is this your signature? On the next document that's titled trial court certification of defendant's right of appeal, you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box is checked states that you're waiving your right to an appeal. Do you understand that statement? And Ms. Lumpkin, before you signed and initialed these documents, did you read the documents? Did you understand what you read?
Yes.
And is everything in these documents true and correct
Yes.
to the best of your knowledge? Ms. Lumpkin, are you a citizen of the United States?
Yes.
State offers states one.
Ms. Lumpkin, the state is offering State's Exhibit number 1 to be used as evidence in your case. State's Exhibit number 1 is the first document, that I showed you on this tablet. This is the first document that I showed you on the tablet. This is a document that have your initials in these 2 locations and your signature at the top above the line that's titled defendant. Is it all right for the state to use this document as evidence in your case? Okay. Ms. Lumpkin, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Ms. Lumpkin, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
In exchange for defendant's plea, the state is offering 1 year deferred probation, $300 fine, 40 hours of community service, theft class plus court costs.
What is Ms. Lumpkin's court cost?
2 seconds. Yes, to the school.
That's the same thing right there. Yeah. Ms. Lumpkin, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $277. You'll also be required to pay a probation fee of $6 a month, you're not to pay $15 a month, and reimbursement fee of $15. Your total monthly installments in this case is $136 a month. Will you be able to pay the $136 each month?
Yes, sir.
You will also be required to perform 40 hours of community service, attend and complete the theft class, and as well as adhere to the other standard terms and conditions of this probation. Ms. Lumpkin, do you understand the state's offer?
Yes, sir.
You think the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Okay, Ms. Lumpkin, I'll follow the plea bargain agreement that you've entered into with the state. Ms. Lumpkin, please stand in front of the court coordinator, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go and you have a blessed day. Jose Landera Chavez.
Good. Now we know we need an interpreter for him and they're gonna learn.
Okay, Ms. Mr. Chavez, I have before me a document that is titled I have a document that's titled Affidavit of Indigenous. You recognize this document? On page 2 of the same well, now before you sign this document, did you read the document?
Yes.
You understand what you read? Is everything in this document true and correct to the best of your knowledge? Now, Mr. Chavez, let's see, court. Which one is his? Chavez. Okay. 377. 577. Okay. Now, Mr. Chavez, Chavez, I have before me this document is titled Affidavit of Indigenous. And is everything on this document still true and correct today? Now, Mr. Landera Chavez, the court is going to find that you're indigent based on the finding of indigence. The court costs and fine, which comes to a total of $777, will be converted to community service. We converted to 46 hours of community service that you would have to perform. Do you understand that?
46 hours?
Yes. This is I'm converting your fine and court costs to community service. So instead of paying it, you'll work it off. You understand that? Now, the $15 reimbursement fee will be, and that's pursuant to Article 42.15 of Texas Code of Criminal Procedure. The reimbursement fee of $15 will be waived pursuant to Article 102.018 of Texas Code of Criminal Procedure. You will be required to pay $6 a month probation fee and the $15 a month for your analysis. And your total monthly installments is $81 a month. Will you be able to pay the $81 a month? You will? Okay. Now, you will also be required to attend and complete a theft class, and you'll be required to adhere to the other standard terms and conditions of this probation. Now, Mr. Landeris, do you understand the state's offer and the court's adjustments, the court's findings? And do you think it's fair and just? And do you accept it? Okay, I'll follow the plea bargaining agreement that you have entered into with the state. Now, you're going to have a seat in that first chair on the wall and wait for your name to be called. First chair on the wall, right there, on the wall. Darius Moore Lockett. Okay, Mr. Lockett. I have before me a document. Okay, I have a document that is titled, Affidavit of Indigence. You recognize this document?
Yes, sir.
Now, Ms. Lockett, before you signed, this document, did you read the documents?
Yes, sir.
You understand what you read?
Yes,
Is
sir.
everything in this document true and correct to the best of your knowledge?
Yes,
Okay,
sir.
Mr. Lockett, court is gonna find that you're indigent. Let's see. Seven. Okay. Okay, Mr. Lockett, the state is offering that you serve 180 days in Jefferson County Jail. You will not have to serve any time in Jefferson County Jail because you'll be on probation for a period of 15 months. During the 15-month probationary period, you'll be required to pay a fine of $500, the court cost of $277. Now, the court has an affidavit before it, and everything is in this affidavit is true and correct.
Yes.
Okay, so the court is gonna find you indigent pursuant to Article 42.156 Code of Criminal Procedure. The fine of $500 plus court cost of $277 will be converted to 62 hours of community service. Now, forgot to tell, Mr. Landera Chavez, you're gonna be doing a total of 86 hours of community service because you had 40 hours of community service that you was also supposed to do. You understand that? The 46 plus the 40 is 86 of community service.
Instead of 40, you have 86. It'll be on the paperwork.
Okay? That's community service because your fine and court cost was converted was converted to community service, 46 hours of community service. And you also had another 40 hours of community service, which comes to a total of 46 hours of community, comes to a total of 86 hours of community service. Do you understand that? Yeah. Well, you said you couldn't afford it. That's why we did that.
36 a month.
That's calculated in the 136 a month.
Oh,
Okay. Now, Mr. Lockett, the state is offering that you serve 180 days in the Jefferson County Jail. However, you will not have to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 15 months. The court has found that you indigent based on the finding of indigency. The court cost of $277 and a fine of $500 will convert it to 62 hours of community service. The probation fee in this case will be reduced to a statutory minimum of $25 a month. You will also be required to pay the reimbursement fee, your analysis fee of $15 a month. And the reimbursement fee of $15 will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. So your total monthly installments. I thought I had added it. Let's do this here. This thing here is not on. That's not good enough.
Yeah, it's not listed on the docket, but you have some. Okay.
Okay, here we go. Now your total monthly installments is gonna be $41 a month. Are you able to pay the $41 each month?
Yes, sir.
Okay. You also be required to perform 50 hours of community service in addition to the 62 hours of community service, which comes to a total of 112 hours of community service. Do you understand that?
Understood.
You also be required to did he have a theft tax in it or not? He did. I don't see it on here.
I don't think I put it, that was not part of my offer, Your Honor.
Okay. You also be required you will require to adhere to the other standard terms and conditions of your probation. Mr. Lockett, do you understand the state's offer?
Yes, I do.
You think the state's offer, as well as the court adjustments, are fair and just?
Yes, I do.
And do you accept the state's offer?
Yes.
And, okay, I'll follow the plea bargaining agreement that you have entered into with the state. So Lockett, just have a seat, wait for your name to be called. Once your name is called, you'll go to the window where your name is called.
Ok, entonces te cambiaron la corte hasta enero 17 del otro año a las 9 de la mañana para que te dé tiempo de conseguir tu abogado. Ok, ok.
All right, you're free to go. You're welcome. Okay, this is cause number 24 CCCR 2170, case of South State of Texas versus Quintina Gilmore. Quintina Gilmore was scheduled to be in court this morning at 9 a.m. At about 9 a.m., of course, bailiff called the name of Quintina Gilmore at the courthouse door. Quintina Gilmore did not answer. Quintina Gilmore has not appeared in court since the court's been in session. The time now is 12:34 p.m. on today's date of November 19, 2024. Ms. Bailiff, would you please call the name of Quintina Gilmore at the courthouse door?
Christina Gilmore.
Yes.
Christina Gilmore. Christina Gilmore. Terrence,
Quintina Gilmore's name was just called again at the courthouse door. Quintina Gilmore did not answer. A reasonable time has passed to give Ms. Gilmore an opportunity to appear in court. She has not appeared in court. State, do you have a motion? That motion will be granted. Quintina Gilmore's bond will be forfeited and warrant should be issued for her arrest. And clause number 24 CCCR 2170. Next case is Style of State of Texas versus 24. The style is Kalen Quaid Johnson. Kellen Quaid Johnson was scheduled to be in court this morning at 9 a.m. At about 9 a.m., of course, barely called the name of Kellen Johnson at the courthouse door. Kellen Johnson did not answer. Has not appeared in court since the court has been in session. The time now is 12:35 p.m. on today's date, November 19, 2024. Ms. Bailiff, would you please call the name of Kellen Johnson at the courthouse door?
Caitlin Johnson.
Yes.
Caitlin Johnson. Caitlin Johnson. Terrence John.
Kellen Johnson's name was just called at the courthouse door. Kellen Johnson did not answer. A reasonable time has passed to give Mr. Johnson an opportunity to appear in court. He has not appeared in court. State, do you have a motion? That motion will be granted. What's the other person? That's the only one I see. That's the only two I see. You said it was three. What page? Oh, I appointed Lori Perazzo to him. I didn't. Oh, Christopher Henry. Okay, so he wasn't here.
Who is that?
Eduardo Stupino Carrillo. I had him as being marked here. Okay. Eduardo Estupin Carrillo was scheduled to be in court this morning at 9 a.m. At about 9 a.m., of course, be able to call the name of Eduardo Estupin Carrillo at the courthouse door. Mr. Estupin Carrillo did not answer. He has not appeared in court since the court has been in session. The time now is 12:37 p.m. on today's date, November 19th, 2024. Ms. Bailiff, would you please call the name of Eduardo Estupinian Carrillo at the courthouse door?
Yes, sir. Eduardo Carrillo. Eduardo Carrillo. Terrence John.
Eduardo Carrillo's name was just called to get at the courthouse door. Eduardo Carrillo did not answer. a reasonable time has passed to give Mr. Carrillo an opportunity to appear in court. He's not appearing in court. State, do you have a motion? That motion will be granted. Mr. Carrillo's bond will be forfeited in clause number 24 CCCR 2148. And the warrant should be issued for his arrest. This was conclude the calling of the court's arraignment docket on today's date of November 19, 2024, in County Court Number 2, Jefferson County, Texas. Judge Terrence Holmes presiding. Everyone, please have a blessed day. Okay, did y'all check? Did somebody check Joe Martin's case? See if if I have a representative or not.